We're on the record in 231-500-139, State of Utah versus Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present. May we begin by confirming whether or not there's any legal discussion we need to have regarding the text message excerpt that the defense offered during cross-examination of Detective O'Driscoll at the end of the day yesterday.
Yes. Yes, Your Honor, I think we do. May I stay seated so I can read my...
Of course.
Okay. Just 1 second. Let me pull it up.
If we can all look at it at the same time, I'd appreciate it, Katie.
Are you pulling up the Celebrate one or the... Okay. So it's up on the screen right now. So it starts with Bates number state, STATE, 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Miss Gibson.
Can you show me the Celebrite?
Yes, sir. We can, and we're pulling it up right now.
It's a very big file, so what I've done is I've emailed Katie the cover page, and then I'm working on the box download so she could download it.
Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right.
Typically, these are a complete string that has a Celebrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them, not all of them.
I don't know. Is that true? I thought
That's
all of them had the Celebrite header.
No, that is not true.
Hold on. Let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, we've had CDR related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Celebrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Celebrite extraction, it has the Celebrite header.
Right.
There's others where we just, we've got texts from other means. Somebody sent us forwarded this text, right?
Right.
But if
Screenshots, for example.
correct.
Yeah.
If it comes from a Celebrite extraction, as best I recall, it has the Celebrite header.
Okay. And Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th. So it's from the 3rd.
Okay. These 3 bubbles are the sum total of their text traffic on the 3rd?
We have more than 3. There's just a minute. There's a couple pages to it. It's the last set of text that they, there's multiple, see, that's the second page. And, yeah. And that's the last text that they had between the two of them before.
Can you go to that one, please? Katie, can you blow up the third one on that sheet? So as I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yes, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate,
Well,
correct?
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected. And I would expect for the Celebrate downloads that we have authenticated and laid foundation for, the time change is baked in.
Consistent across the
Consistent across the board.
Right.
So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrate download it came from. And I still don't know.
So that brings us to, is there a version of this that has the Cellbrite header?
that's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No problem.
It's very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Oh, are you on a Mac? Oh, God. Our millennial has a Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody. If you can have it with each other first and then distill down what the dispute is, if any. Regarding foundation,
Yeah.
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we could work parallel while they're seeking out the foundation information. We could address a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Ms. Nestor, regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, excuse me, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd. And that was sent the day before. That is connected to the GIFs, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What is the photograph of and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there before he gets home that night. that is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at 8:40 as soon as the police leave. And they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was, the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're
Okay.
trying to explain to the jury. All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you doing this through Detective O'Driscoll? Why didn't you do it through Mr. Kotradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of it we'll do separately.
But that's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant, and I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's
But
all I
without the
care about.
metadata, the picture is not relevant.
Well, the
You need the date and time.
We have that. No. We do need the date and time, but I'm talking about the, I thought there was more information on the bottom of those things. And we
Why
can
are
take
we
that.
doing this through Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file path for the GIFs and the file path for this photograph?
Because he reviewed it and saw it. I mean, I think he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct. And we're not asking for that. That's all we're asking him is to say that the picture was sent the 3rd. That's all I need him to say. And he knows that because he reviewed it. So he's
He
capable.
knows what he saw. How
Right.
does he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said, yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm
Is
not
that-
asking him for
I'm
any
not sure
technical.
that's even in dispute. Go ahead, Mr. Bloodworth.
Let's never come out before on any other witness.
Okay. But go ahead, Mr. Bloodworth.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
If the yes or no to the question of did he review Eric Richins' text messages from the
I think that's already been answered. Yes
okay,
or no.
yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
It's not in, but we've stipulated.
we've stipulated is coming in. next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in
We've stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What,
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see on, I still think there's a hearsay problem. Based on counsel's explanation now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo.
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publications, the hearsay, the fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense has, the defense is, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died? Yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd? Yes or no? Yes. Is this the photograph that he sent? Full stop.
Oh, I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh, no, fair enough. I'm not telling him how to testify, and I don't
Understood.
know what he'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand? Do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs
You
to
can't
be.
show the text messages without provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh,
Because
that's
I think it's got to be. He's not going to know. It's just going to be a weird picture.
understood.
Should we just go ahead
Are you
and
going to publish the photo to the jury, though?
no?
Okay.
So, we could just go ahead and admit 340 now, because then the next question is going to be, is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now there's the follow on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
So
it. I'll do
somebody
it.
going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other issue. If we're resolved with this, I think we're all clear. I know what I can ask, what I can't. I think we're fine.
Okay.
There's another issue. May I bring it up?
Please.
All right. I really need Officer Driscoll to leave the courtroom when we talk about this because it's
Oh.
about specific questions.
No problem. Detective, if you'd take a step into the lobby, please don't talk to anybody while you're out there, sir. Thank you.
Okay. Thank you, Your Honor. I'm doing this out of an abundance of caution to avoid any potential. I'm trying to be very careful to comply with the court's ruling on the motion in limine not the motion in limine, the motion to admit the statements of David Norris. So
Not.
correct.
Yeah.
Our motion to admit that was denied.
Yes.
So just to make the record, the defense sought in advance to get approval or actually we gave notice to the state that we intended to call a witness named Mr. Norris, who would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl. He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but
Correct. The court the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
the residual.
The residual, I'm sorry, I call it catch-all, same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got it right.
I'm sorry, I do have these if you want me to email them to you.
No, it's okay. Just
Okay.
give me a moment.
No worries.
Was it prior allegations that Eric?
Any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Got it.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about about an incident where Eric allegedly asked someone for fentanyl? Want me to read that again?
Sure.
and within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl? And then there's one more question. Let me know when you're ready, Your Honor.
Sheriff investigative team, give me the last clause one more time.
Who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl.
Okay.
And the final question is, did you or anyone else connected to the investigative team ever sit down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims? And that's it.
Mr. Blood.
No objection to the first question. Objections to the next three. This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, or he was calling because defense counsel told him he should call.
Maybe we just pause here for a moment. I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there's no there is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them.
That's not the question you asked. Read the whole question.
In order to properly investigate,
No. Go to number 2.
that is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
That's a fair question.
It would be reversible error for me to allow that question. There were 2 residual exception rulings in this case. Let's be fair about it.
Right. That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed. And they are like, no, thank you. I think I'm entitled to get that in, and I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible. But I do believe that's fair game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look like you're about to say something. I'm sorry.
No, Your Honor, as I understand the status quo is the court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's investigation of the charges. Yep.
Your Honor, no, it's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the balance of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far, and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence is already admitted.
I think it's his knee surgery,
Is
right?
a 2016 hydrocodone prescription following knee surgery.
Right. Okay. Very good. Now, by the same token, I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any kind is already in. Correct? And all is putting it strongly, but
Yeah.
that is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in a rebuttal case.
Understood. Okay. which was the basis, among other things, of, not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you were accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true. And then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office or Sheriff's Office? My apologies.
Yeah.
He says, yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely. And we don't.
If you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on, fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth. It's being
100%
offered,
being offered.
Your
for the
Honor,
truth.
if I may please, it's being offered for the same reason they've gotten in a ton of other hearsay in this case, by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in Woody, the Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how that the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor, then
Yes.
the 807 residual exception wouldn't exist and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got to get something in context so the jury understands, hey, you had this road, you chose not to go down it. That was your choice.
I appreciate why you want to present this to the jury, but there are limits
Right.
on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence. For the same reason that the state could not argue that we want to get in Hayden Jeff's statements to its sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do. Here, it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance isn't admissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
We have just a moment.
Sure.
Okay, Your Honor, I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
Let me take a minute. Let me just take 5 minutes.
Thank you, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay, I'll be right back. Thank you.
All right.
record in 231-500-139. Counsel, thank you for your patience. I've just handed you a copy of State versus McCullough, 2014 UTF 215. Need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this. I can't unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bonsavage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement into question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bonsavage, they're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Your Honor, agreed. There's a little more to unpack here too, because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. We also have the problem that
We meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris, or they call David Norris.
Sure.
And they ask, did you
Sure.
call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Hayden Jeff statements and the Nick Bonsavage statements, that would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think we
Fair.
would like to get out in front of this
Okay.
before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would want to continue that investigation.
I think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did,
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Yeah.
I don't think so. My only point in mentioning that is it would just take a little bit of time and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner, it's both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Bonsavage, does
Mhm.
that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law
Sure.
enforcement's investigation, not for the truth.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nick Bonsavage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
Is when you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial Well, I guess there's once a call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with a patrol deputy, and then there was a contact with a detective.
Okay.
And then we have the affidavits that he'd submitted, that defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
I'm familiar with what you're referring to. I'm a little less clear on that.
Sorry,
Yeah.
Profer is, Profer is the,
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
Your Honor, the proffers do tie into this in that, the question would be, did this inform your investigation? Yes, we considered all of his statements to include the defense proffers
Got it.
in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion or argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need.
It's jury confusion.
Right. And
Yes.
so what is it you believe they would be confused about?
I think they would. I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris, whereas those waters are crystal clear in the case of Hayden Jeffs and Nick Bond Savage. And the waters are muddied as it relates to Mr. Norris very deliberately. And that and I don't know. I suspect the purpose is to confuse the jury, right?
As you sit here today, have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know, I don't remember the name. I know the patrol officer. I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so
You would be able to call an investigator, not a lawyer, right?
right,
Yeah.
So probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I mean, I appreciate that Hayden Jeff spoke directly to law enforcement in a recorded interview.
Right, that's what we would have to get into. What did you understand? Why? With what level of detail? Which is extraordinary.
In there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Bond Savage jail call, right? That entire jail call comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court in in considering the weight of the various prejudices, the prejudice with admitting Norris, versus the prejudice of the Hayden Jeffs and Bon Savage. I think the court needs to in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that David Norris's assertion is not at all probative because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case. Whereas the Bon Savage statement and the Hayden Jeff statement is highly corroborated with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403 balancing.
I understand your position.
Okay.
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high stakes poker.
Yes, it is. I was just going to ask you if we could have a little time to meet with our client next door. She's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth, but for their effect upon law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent investigation, that by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Bon Savage, not for their truth, but to show what they were doing and how they were doing it.
Can I just get a clarification on the Bon Savage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bon Savage and an inmate in Gunnison, they're discussing purchasing a PlayStation controller, and they're discussing who's going to pay for it, kind of how to get the money for it. And Nick Bon Savage says to the inmates something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
The word
substituted the word fentanyl
We
for
illicit
illicit
street
street
drugs.
drugs.
Right. And that's a recording,
It is a recording.
as is Hayden Jeff's interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a Profer discussion.
Right. Okay. How much time do you want, Ms. Nestor?
We have 30 minutes. Thank you, Your Honor.
Anything else before we take a recess, Mr. Glover?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30. All rise. We're back on the record in 231-500-139. Counselor present, Ms. Richins is present. Ms. Nestor, you've had an opportunity to confer with Ms. Richins. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still, he is not the foundation witness because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
And if we decide to go forward with that evidence.
I appreciate that. If you make that ultimate decision,
We'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that. And I think that's probably a good idea for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of status quo, we are going to proceed with additional cross-examination of Detective O'Driscoll, correct?
Yes, sir.
Did we reach I'm sorry.
Could we just go ahead and, well, I can just do it through, I think we decided I would just ask him about 340. I'm sorry, and I apologize. I
Okay.
withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in. And then I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340. And then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date, it's a yes or no question.
Correct. Just
Okay.
on the date, not the time, because I don't want to confuse anyone or require the UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Zach, please.
2, 3.
What's that? Take it off.
Okay.
All rise for the jury.
Please have a seat as you come in. All right, have a seat. Thank you. Ladies and gentlemen, thank you for your patience. We will now proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom. Detective, please step in front of Brittany. We'll get you sworn back in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Thanks, Zach.
Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
State's exhibit 3-40 is admitted.
All right. And this was talked about when I believe it was Mr. Kostradimos, I think it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
All right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Cocherdemos, yes.
Okay, can you pull up another one of the photos? That is the picture from the house. That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the legacy mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11. Not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better? All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure. And it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed? Correct?
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I think,
Can we back up a step? Maybe I'll catch up.
sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone
Yes.
on the day before he died.
Yes.
I don't remember all of them. I
Okay.
remember some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
No, sir.
Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes, Your
So,
Honor. Sorry, objection. Foundation is to the meaning of died, right? He was pronounced dead.
I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Corey on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection, his recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question about the photo and then I'm done.
I'll take you down, ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you were about to
Yes,
ask.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen and the witness is
I apologize. There you go.
staring at it.
Sorry.
Ooh.
Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
One more step. If we could go back to 340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time.
Yes.
And the one with the farmer is that exact same time.
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect. Thank you. Okay, we can take that down now. All right. I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Cocherdemos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Foundation, yeah.
Sustained. Lay a little foundation there.
Are you aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to she was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute, I have the number. I've got it. I'll tell you. Just one moment, I'm sorry, Your Honor. It's hard to keep all these exhibits straight. Can we put up exhibit 2-66R? It's admitted, Your Honor. Oh, wait, I'm sorry. Before we do that, can we put up exhibit, 2-66R? That's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it. Two 66R, publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kids school notebook, right?
Correct.
Okay, and can you fast forward, Katie, until I tell you to stop? Keep going. Keep going. Keep going. Keep going. Okay, right there. And can you blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that?
Mhm.
You need to say yes.
Yes, sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
Your Honor, maybe approaching.
I'll move on. I'm done with that. You
Are
don't know,
we
so-
approaching or moving on?
Why? We're moving on from the subject matter. No need to approach.
Got it.
We are moving on from the subject matter.
Very good.
All right, you also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed a Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it. Yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that
Scott,
one's got things
would you
blurred.
help us out? Thank you. Let's see. This is
Yeah.
8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Katie does have this one if you wanted to switch back.
Okay,
Yeah, because I'm going to need her to blow it up. Can we
One
switch it
more.
back to her, please? I'm so sorry.
no problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you see another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right. Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up exhibit 2 dash, I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
All right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had. I guess it depends on the timing that you're asking about.
Okay. I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination. Okay.
Okay.
Can you blow that up? It's exhibit 2-3D as in Delta. And just let him look at all of them, please. Just slowly. Give him plenty of time to read. Can you go back up? I think we're missing that one. There you go, the next page. Does this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor. Your Honor, may I approach the state?
No, that's not true. It's hearsay. Yeah. We're working on something, but I'm going to ask a couple more, move back, and then we may come back to it when she's done looking. So was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed? Objection, Your Honor. More foundation, otherwise it's based on hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it, there may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor, foundation. That's not what happened.
I think your recitation of Ms. Daking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Mistaking from my memory testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Corey's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor. Is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital.
Any,
So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
were you ever able to confirm that he did?
No.
Okay. All right. I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Lobber's. She worked for Doreen Kouri cleaning houses with Carmen Lobber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lobber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second. The relevance objection is sustained. Ms. Nestor, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lobber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills in in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Kocher-Demos.
And you also reviewed the phone calls. Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up. Anything else? All right, we're almost done. So just to recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah,
And
or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The medical examiner's office.
They're not a law enforcement agency.
Well, they have investigator, right? She testified here.
Yeah.
Okay,
They're a civilian investigator.
fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything else that had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay. You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company. Have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach for 1 second? State's objections are overruled. If you would restate that question, if you can, exactly. as
I will.
Mr.
And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the
Okay.
law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection, well, not objection, maybe approach.
Sure.
Thank you.
Okay, I'll withdraw that question, Your Honor. And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
Not Eric,
not Eric.
but he could not say that it was signed by Kouri, correct?
Correct.
Okay. I think that's it. I appreciate your patience. Thank you, Detective. Thank you, Your Honor. We tender the witness.
Mr. Bloodworth, within the scope of cross, please.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes,
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes,
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
no, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Cotrodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you this.
January, 0.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when me charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cotrodimos and Ms. Carrington?
Yes,
And is Mr. Cotrodimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
yes,
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lobber, where it was either you or Detective Maynard told Carmen Lobber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
She
did-
had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
We
did it
didn't even get into that until well after.
predate any of Mr. Cotrodimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Need my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lobber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building
To this building?
to
or
meet
this
with prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No,
Can investigators seize someone's cell phone without a warrant based upon probable cause?
no, it has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes,
The gift image, the one with Kevin Spacey that says idiots, idiots everywhere. Is that from the TV show House of Cards?
from my understanding, yes.
Thank you.
I'm sorry, is he finished? We have no further questions. Thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Thank you, sir. Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. So if the state could, I think we've marked it as 865. We'll admit
objection.
that now.
Okay. Can I see it for a moment?
Your Honor, ma'am.
Please. Do you want me to give the Mujisik stipulation of fact preamble and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. States Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth,
Your Honor, state's in an interesting posture.
do you need a moment on the record outside the presence of the
We
jury?
do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be able to it seems likely to me, you tell me, that we'll be taking a recess now, but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you a steak dinner. It's going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bailiff.
All right, the jury. It's a lot of steaks.
We have lunch coming today, right? Okay, very good. That's fine. I just think they appreciate Ellie.
Yeah.
Have a seat, folks. Thank you.
I knew you were on it.
All right, Mr. Bloodworth, we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case of chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman,
Bond Savage.
Mr. Bondsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or an account thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Miss Richins, or rather True Stage left the voicemail with Miss Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Miss Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Miss Richins sought and procured oxy from Miss Lobber, that while Miss Lobber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl. Rather, he provided prescription grade oxys. From that moment, from the supplier, Mr. Crozier, to Miss Lobber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lobber 15 to 30 bluish pills marked M30. Carmen Lobber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl.
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level non-prescription pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again, according to the criminal information, had indicated a phone number with an incorrect digit. The signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or
The P.O. box, circumstantial evidence that Eric didn't know about it.
not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer your Honor's question. Also, an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant. Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lobber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lobber. This same argument, not to rehash it, applies to count one. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lobber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when, she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, if Mr. Bloodworth wants to respond to this. I did neglect in my argument initially as to count 2, the testimony regarding the, I guess, the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor, heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. Appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
All right.
Okay, we're back on the record in case 231-500139. Counsel for the state are present, counsel for defendant and the defendant are present. The issue before the court is defendant's motion for a directed verdict seeking dismissal of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further until before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor.
No, sir.
All right. We'll be in recess until 1 p.m. Just confirming that to the extent the defendant will be putting on evidence and calling witnesses, you have a couple in the wings. Is that
Yes.
correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess. And 231-500-139. State's counsel and defense counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yeah, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
We're ready to go.
Who's defense counsel's first witness?
Oh. Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
You don't want to. Your Honor, actually, at this time, the defense intends to rest,
We should probably do that in front of the jury, yes?
right? I
Okay.
agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the
Yes.
record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you two direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah,
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
So let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin, the parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought, we were thinking it might make sense to get the jury instruction conference out of the way and then,
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
yeah, yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth,
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay. Please have a seat as you come in. Have a seat. Thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning. I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence. I need you to use that same affirmative effort and diligence to make sure you avoid watching, listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe. Enjoy your weekend. I'll see you at 8:30 a.m. on Monday. Please rise to the jury. All right, folks, have a seat. May I propose the following? That counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest?
Late as possible.
Want to do it at 1?
Yes.
Sure.
Mr. Bloodworth?
Sure, sir.
All right. So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you.
All rise.